And on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to today's session of the Appeals Court. It is February 11th, 2021. The first case on the docket today is 2020 P146, the Commonwealth versus Vincent Purdie Jr. Counsel, when you're ready, you may proceed.
Thank you. Good morning. May it please the court. My name is Anne Rusev and I represent Mr. Vincent Purdie Jr. This case is an appeal from a probation violation hearing. I briefed two sets of issues, one pertaining to the violation phase and the second pertaining to the sentencing phase. I'd like to just spend a minute on the violation phase issues before I turn to the sentencing errors. The overriding problem in the violation phase, the wellspring of all of the errors that I briefed in this phase, is that the judge had already made up his mind before hearing any of the evidence in this case. And the judge's comments make this very clear. He asked, why are we doing this? This is a lot of hearing for an easy decision. There is no point in doing this hearing. This is just for discovery, so let's limit it. He referred to the hearing as a waste of time, not once, not twice, but 3 times. And he even described
Counsel, as I read the transcript, some of those statements I thought, and I may be wrong about this, related to the co-defendant's case. And wasn't it the judge who actually, as to your client, suggested that he would need to hear evidence as to the alleged new violations?
He did say that because there were the administrative or the non-criminal violations, there was not enough evidence of the change of address and the fees. But he did say repeatedly the fact that a criminal complaint had issued in Wareham was dispositive. He said probable cause has already been found by a neutral magistrate, so there's no point. But then the hearing did proceed. And I think because he had already made his determination based on the issuance of the criminal complaint, which of course is not sufficient for a preponderance of the evidence, because he had already made this decision, he was careless with the basic mechanics of the hearing. He denied routine motions very dismissively, like the motion to sequester, the motion to allow Mr. Purdie to sit with counsel rather than in the dock for the hearing. These were totally appropriate, reasonable motions that were summarily denied because in the judge's words, this was not a trial. Even though Mr. Purdie was facing—
Counsel, it's not uncommon in a probation violation action to have a defendant remain in the dock. Is there some particular prejudice that you allege your client suffered from that decision?
There's nothing in the record that indicates that there was an inability to consult with counsel, but I think it's just one more example of the carelessness and the dismissiveness with which this judge treated this hearing.
Let me ask you this, counsel.
Yes.
The fact that you characterize it as careless or dismissive, if the evidence was more than sufficient to find a violation, would that override any aspect of the so-called carelessness or dismissiveness without getting to the sentencing? Just the finding of a violation, if the evidence was more than sufficient or overwhelmingly sufficient, is that enough to overcome that? Where there's no maybe express prejudice?
In this case, no. There was a contested issue in this hearing. It was about whether these facts showed trafficking or simple possession. Probation Department alleged that these facts showed trafficking and conspiracy. Mr. Purdie's counsel argued that this showed simple possession. The way the judge approached the hearing shows that he did not grapple with this issue because he decided that the criminal complaint was sufficient to show trafficking. So all of these errors that I'm describing impacted his finding of violation.
But either possession or trafficking was sufficient to get him to the sentencing phase of a violation once he's found a violation.
Yes.
All right.
So, so raising that issue then on the mootness question, I understand what you're saying is that he pled to possession. And I guess my question is, if you plead to a lesser included offense, then, do you have a mootness issue on the disposition?
Well, under my law, the disposition is never moot. Only the errors pertaining to the first phase are moot. And I think in this case, because the judge found, he didn't make written findings, but I think we can infer that he found that Mr. Purdie violated by committing the trafficking offense. If he, the fact that Mr. Purdie eventually pled to possession means that there's a difference in terms of the sentencing, because the judge went into the second phase, the sentencing hearing, believing that Mr. Purdie had violated by virtue of trafficking. Had he gone into it with the offense of simple possession in his mind, the sentence could have been very different.
Right. That's the point, though. Let's say that we were to reverse, okay, on all issues, then what would be the impact on whether there was a probation violation when you go back where he's pled to possession related to these charges?
So that if the court were to reverse on all issues, then there would need to be a new hearing for a judge to hear evidence to decide whether there was what's an appropriate violation finding. Is it just the simple possession, which is what counsel argued and what Mr. Purdie pled to, or would it be more than that? And if the judge can consider the nature of the violation at sentencing, then it does matter what the actual violation is found.
Well, to what extent does the judge consider the nature of the violation at sentencing? I mean, he's sentencing on the underlying offense.
He is supposed to, yes. And in this case, I think it's very clear that the judge was not sentencing on the underlying offense because he spends the entirety of the sentencing hearing focused on the new offense, talking about his loathing for drug dealers, and his entire inquiry was about whether Mr. Purdie was a drug dealer, and asking the DA to provide him information on that issue, hearing from the probation department on that issue. And once he received information from the Falmouth detective and from the probation officer, he apparently was satisfied that Mr. Purdie met the criteria because he wrote drug dealer in all capital letters on the violation form.
I didn't see anything at that phase relating to the underlying offense. In other words, whether the judge was even familiar with the facts of the underlying offense for which he was actually sentencing. Was there anything in the record that indicated the judge had familiarity with the underlying offenses?
There's nothing in the record. I don't believe there's any indication that he reviewed a police report or took any evidence as to the underlying offense. He does ask a question early on in the sentencing hearing where he asks if it's a possession type offense. But other than that, all of his questions, all of his comments are related to the new offense and whether or not Mr. Purdie meets the criteria of a drug dealer.
Right. So, and I don't mean to pull you, I guess we're pulling you into the sentencing phase, but to what extent does the nature of that offense impact on the sentencing of a probation violation? Assuming there's a violation, a valid violation found, to what extent can the judge consider the nature of the new offense?
Right. It's tricky. I think you have to start with the premise from the case law that you are to be sentenced on the underlying offense, and that comes from O'Doherty and Rodriguez and those kinds of cases. Where it gets tricky is that there is a line of cases, Coleman and Goodwin, that say that it can be appropriate to consider uncharged crimes if it's relevant to the defendant's character or rehabilitation. And I think in this case, it's a delicate line when you can use untried conduct for those purposes. And maybe in a normal case, you could presume that a judge sort of correctly instructed him or herself on that permissible use. But in this case, given the judge's language, given his extreme comments and his inappropriate behavior and all of the other errors that he made, you cannot be confident on this record that he used this type of evidence in an appropriate way.
Could I ask you? I'm sorry, go ahead.
No, you go ahead.
Well, I'm confused on the underlying offense as to the Class A offense. The probation record seems to have it as a simple possession, whereas the docket has it as a possession with intent to distribute. Has that ever been clarified in any, or was that clarified? I didn't see it clarified at the hearing, but so it remains that way on his record as a possession, but the docket reflects a possession with intent.
That's absolutely correct. It appeared that all parties maybe were working off of the criminal record at the hearing because it was consistent. The judge, the DA, the probation department, Mr. Purdie's counsel, everyone treated count 8 as a simple possession. And I think in terms of evaluating the errors at sentencing, what's relevant is not what's on the docket, but what was in the judge's mind at the time. The judge believed this was a simple possession. He explicitly asked the DA what the maximums were on those charges. And after finding out it was a year, he sentenced Mr. Purdie to a year on that, a year on the other count, and then the 9 months. So the judge very clearly ascertained the maximums and then sentenced Mr. Purdie to the maximums, all to be served consecutively. So the judge's intent was to give him the maximum he could. And that is what shows his animus and the fact that his hostility, his self-professed hostility for drug dealers impacted the sentence.
So, counsel, though, in light of the testimony of the 2 troopers and the availability of a video of the transaction that defense counsel agreed on the record was consistent with that testimony, how do we conclude that anything but that the evidence that the defendant had committed a new crime on probation was overwhelming?
Well, as defense counsel argued, I think there was certainly sufficient evidence for simple possession, but there was this contest between whether the violation showed trafficking or possession. And that discrepancy was relevant to the judge in the decision to revoke. So I think that discrepancy is why the nature of the violation matters. If I could turn back to the sentencing issues, if there are no other questions.
I
So,
have a question on the sentencing issues, actually. So
yes.
What's the basis for claiming that the judge relied on the testimony from the absent detective in the sentencing?
Well, first of all, he solicited that information from the prosecutor. At the end of the first hearing, he said, I need to know more about Mr. Purdie. He asked the prosecutor to speak to detectives. He even said, it can be hearsay. I will accept hearsay. And then once he was provided that information, he wrote drug dealer in all capital letters on the disposition form. So I think given the sequence of events where he specifically solicits this information and then he writes drug dealer on the finding and disposition form, I think that the evidence shows that he did in fact rely on that information that he specifically solicited.
Do we even know the name of the detective?
If memory serves, I think that the prosecutor may have mentioned the name of the detective, but I believe it might be in the transcript. But there was not a police report. There was no other details of supporting this opinion. It was just the barest of accusations, devoid of detail, no sense of the timing of when he developed this opinion, how close in time that was to the hearing. So I think on that issue, even under the rules of the probation violation hearings, that would not be sufficiently reliable as hearsay. So it was an error to rely upon that.
So it was basically a general character information from, at the request of the judge, for the prosecutor to get his general character as perceived by the local police.
Yeah, and specifically about whether he was a drug dealer or, I think in the judge's words, a hapless user. And the judge made clear that this distinction was critical. He said, if he's a user, maybe I'll work with him. If he's a dealer, he's facing a lot of years in jail. So this determination was essentially what Mr. Purdie's future hinged on.
Is
I
that
think
improper? Is it improper for the judge to seek out that type of information for a sentencing?
The judge can certainly rely on hearsay, but it must be sufficiently reliable. And I think the Goodwin case really lays out the carefulness. I see I'm out of time. If I might.
That's all right. Finish.
Thank you. The judge in Goodwin was extraordinarily careful in relying on hearsay. It was sufficiently reliable because it was incredibly detailed, and it was the judge was very careful in using that hearsay only to craft individualized probation conditions. It wasn't used to enhance the punishment. It was used to create a sentence that hopefully would assist the defendant in his attempt to rehabilitate. Here, all of this information was used just to increase the sentence rather than to craft a probationary sentence with conditions that could support and encourage rehabilitation.
Thank you, Attorney Rosev. Let me see if there are any other questions. Seeing none, thank you for your argument. Attorney Palumbo, when you're ready, you may proceed.
Good morning. May it please the court, Karen Palumbo for the Commonwealth. The Commonwealth acknowledges that the statements of the judge were ill-conceived and better left unsaid. The Commonwealth cannot defend the statements made by the judge, but we can address the underlying due process claims that the defendant raises. Since the due process claims, the court must determine if there were any errors, whether those errors were harmless beyond reasonable doubt. As this court pointed out, although the judge was dismissive initially of the underlying revocation, he realized after defense counsel brought it to his attention that there was no evidence that the defendant had committed a technical violation and that he was required to hear the evidence from the two troopers. The judge held a full evidentiary hearing. Two troopers testified to overwhelming evidence. The defense counsel participated, cross-examined witnesses, and defended her defendant's position strenuously to the judge. Also, as far as the probable causes.
Counsel, you're right that there was that the judge he made these statements, but then he said, okay, I have to have evidence. He heard the evidence, not only did we have the two troopers, but defense counsel even said the video was consistent with the testimony of the two troopers. But I think that your learned colleague is basically saying that the overall appearance of this was so unfair that, even if we end up in the same place, we just have to do this again because the system has to have integrity, and we just can't have this kind of statement and this kind of appearance of not being impartial and fair. So what's your response to that?
Well, as far as the fact-finding portion of the hearing, I think despite those statements, it was fair. As the court's well aware, the two troopers testified. There's a video. There was overwhelming evidence that the defendant violated the terms of probation. In relation to sentencing.
Well, before you get to sentencing, what do we do about the fact that the judge didn't make written factual findings, which is a requirement?
Well, written factual findings are a requirement, but they're not fatal if the evidentiary basis is clear. And in this case, it is clear. So I would suggest that
Let me just back up. You agree the defendant was not permitted to sit at counsel table, right?
Correct.
Witnesses weren't sequestered, even though at some point they were maybe going to be testifying in the alleged crimes that were the subject of the revocation hearing, right?
Correct.
The judge misstated the standard of proof and failed to make written findings, right?
Correct.
At some point, he misattributed a positive drug test, albeit it was later. It sort of makes you wonder if it was on his mind at the time. And he made several statements that this was all a waste of time, and he made his ill-conceived statements about loathing drug dealers. So in the face of all of that, you still think that we can affirm?
I do believe that you can affirm. first, he did hear all the evidence, and he did make statements that he should not have made. But the evidence before the court was overwhelming, and for this court, the question is whether the record discloses sufficient reliable evidence to warrant findings of the judge, and it clearly does, at least in the fact-finding phase. And again, as far as written findings, where the defendant was well aware of the written findings, the facts of the case and the basis for the revocation. As far as the drug screens, that happened when Judge Welsh made written findings for the appeals court on a motion to stay, and he incorrectly attributed those drug screens to the defendant. It's clear that he knew that those drug screens did not belong to the defendant at the hearing. He specifically, after determining that Mr. Palazzolo had positive drug screens, he says, "What about PURDIE?" And probation says it's the new charges in violation of status. And he says that we'll have to proceed to the new charges. So the court was well aware that the defendant, at the time of the hearing, did not have any positive drug screens. As far as denying the motion to sequester, that's in the discretion of the judge. It was two troopers who testified to different aspects of the crime. One saw the transaction and one arrested the individual, pulled the individual over and arrested the individual. So I don't see any problem with his sequestration. As far as the defendant not being allowed to sit at counsel table, he makes no claim that it hindered his defense or that he was unable to communicate with his counsel. So I would suggest that also is harmless beyond reasonable doubt. And as far as sentencing,
Can I ask you a question before you get to your sentencing argument, which I understood to be, at least in part, that the judge had adopted the probation department's recommendation. But as I read the transcript, even though the probation department recommended terms on each of the offenses, I didn't understand the recommendation to be for consecutive sentences. Did I miss that?
No, probation did not say the word consecutive. The judge imposed consecutive sentences.
So in that sense, at least, the judge was not following a specific recommendation of the probation department.
No, just the length of time. And again, at sentencing and throughout the entire proceeding, there was some miscommunication, I guess, as to what count 8 was. It was a distribution offense, but it seems as if the judge, probation, and everybody at the probation revocation hearing referred to it as a possessory offense. So,
well, the Board of Probation record has it as the possessory offense.
I saw that, Your Honor. I can't reconcile the difference. I would suggest that he pled to the possessory with intent because the docket says so. And I'm sure the court's aware of it. It's in the Commonwealth addendum at 41 and 51 as well.
Would you agree that the judge's ultimate sentence was consistent with the questioned statement regarding his loathing for drug dealers?
I don't think so, Your Honor. The judge, immediately after finding a violation and hearing from probation, he sentenced the co-defendant to a year committed, and he said he needed more time to figure out how he should sentence the defendant because he was facing 3 lengthy sentences. It was inartful, but in essence, I believe the judge was trying to figure out if the defendant was just a user, he might benefit from treatment and thus be rehabilitated, or if he was more of a drug dealer, then he would impose the lengthy sentences that he could have imposed prior to stating all of this and requesting information from counsel on the defendant.
Do the facts of the underlying offense have any part in the sentencing at a probation violation?
I think that they should. It doesn't appear that they did in this particular case because the court wasn't even aware of the actual charges to which the defendant pled guilty.
And that's what he's being sentenced on, is that offense, not the new offense.
Correct.
And the new offense should not necessarily have any impact on the sentencing for a prior offense for which he's sitting on probation.
Correct, but it does inform the court as to the defendant's amenability to rehabilitation. In that sense, I think it's relevant to the judge's sentence. And also the trafficking charge, with which I know the defendant pled to possession later, but the trafficking charge is a 3.5-year minimum mandatory. So the judge was not punishing the defendant for the trafficking. He was punishing for the underlying offenses. He requested probation inform him of the maximum sentence, and that sentence was appropriate given the fact that the defendant had been on probation for 8 months and violated. So I don't think, despite that awful statement, I don't believe the judge punished him for being a drug dealer. I believe he punished him on the sentenced him on the underlying offenses.
Doesn't it reflect?
What do we make?
Go ahead. Go ahead.
What do we make then of the capital letters drug dealer on the docket?
It's on the probation revocation form, not the docket.
Okay.
But
I stand corrected. I think the question is the same.
Just, I can't defend the judge's statements or the written words of the judge. I would say ill-advised at a minimum to put that on there. But again, there's no evidence based on the sentences that the defendant received that he was punishing for the trafficking. He again went out of his way to try and figure out if this defendant might be amenable to treatment and rehabilitation. He was very inartful in doing so, but I believe that was the intent of the judge in asking all these questions during sentencing. Defense counsel aptly argued that the defendant was more of a user than a seller, but admitted that he did sell to use. So I believe the judge properly sentenced the defendant.
So, counsel, I take it the Commonwealth's not arguing that any part of this is moot based on the plea, right?
No, Your Honor.
So I'm correct?
You're correct.
Okay. And do you agree, was his plea to a lesser included offense of the charges that were before the court on the revocation question?
Yes, originally he was charged with possession of Class B with intent, and that was reduced to straight possession of Class B. And he was charged with possession of Class A with intent, subsequent offense, and that was reduced, and the subsequent offense was removed. So
your learned colleague on the other side here is basically saying that the issue in the dispositional part, not the sentencing part, what was, whether there would be a revocation, and that really turned on this question of possession versus trafficking. So what's your response to that?
Well, I think the judge struggled with that as well, and he states that there was ample evidence. It's either for trafficking or possession with intent. So he was questioning the sale end of that charge. But he found that the defendant at least purchased and possessed the drugs, which is sufficient for a finding of violation of probation. And I think he struggled with that, and that was his struggle throughout the evidentiary portion as well as the sentencing portion.
Was the hearsay on the sentencing from the detective, and counsel was right, we do actually have the name, it's from the Falmouth Police Department, it was Detective Bartolome. Was that hearsay sufficiently reliable for the judge? It's on the second transcript at pages 4 and 5.
At the sentencing hearing, both defense counsel acknowledged that the Falmouth Police had knew the defendant, and the judge asked specifically for the information. Detective Bartolome, who was the detective on the underlying case, provided that information to the ADA. I believe that it was sufficient. The judge didn't rely on it to make the ultimate decision as to whether he would sentence him or impose the sentences on the 3 violations, or whether he would provide the defendant with another probation term and treatment. I believe that that was very relevant, and it was he could consider that in determining whether the defendant was amenable to rehabilitation.
So in the defendant's reply brief, he argues that only one of the 3 sentences, the possession of Class B, was a suspended sentence, and the other 2 were straight probationary sentences that left the judge with wide discretion. What do you say to that?
I believe that is true, Your Honor. There's a case, Commonwealth v. Rougeau, 80 Mass Appeals Court 113, that I did not cite in my brief, but where the original sentences were split and 2 probationary sentences, the 2 charges on the probation remain subject to the imposition of the full sentence upon violation of probation. Would you like that citation?
Yes.
It's Commonwealth v. Rougeau, ROUGEAU, 80 Mass Appeals Court 1113. And that's citing Commonwealth v. Brucisi, which also stands for that proposition.
Counsel, what do we do with the statements of the judge about the test for drug dealers? Is that appropriate for a judge to voice that, which appears to be a biased against a certain offense at the time of sentencing? Can we interpret that as a bias?
It was inappropriate to say that, but given the judge's...
It's inappropriate because it suggests that he was biased.
Well, I don't believe he was biased. If he was biased, I believe he would have sentenced the defendant immediately after finding out that he violated probation. Instead, he took the next step of trying to figure out what this defendant needed, whether he needed to be incarcerated or he needed to be in treatment. So I don't believe it demonstrated bias. Do I believe the judge shouldn't have said it? Yes. And I believe no judge should say something like that on the bench. But I don't think...
I guess going back to one of the original questions of Judge Henry is, does that affect the integrity of this whole process?
No, if it impugns the integrity, I would suggest it's just the sentencing portion. I would suggest there was overwhelming evidence during the evidentiary portion and that the judge correctly found the defendant violated the terms of probation in that. So if it were to be remanded, I would believe it would be just for sentencing and not for the evidentiary portion.
In front of the same judge?
I'm not sure about that.
Thank you.
Thank you.
Justice Kinder. Is his screen frozen?
Well, counsel's argument
Either
was
that or he's sleeping with his eye. But
counsel, your argument was very helpful. Thank you. I think we understand the issues and we appreciate your appearance this morning. We'll try to get Judge.
We are live and on the record.
Good morning and welcome again to this morning's session of the Appeals Court on February 11th, 2021. Before we proceed to the next case, let me make a brief record on our first case, which was 2020 P146 Commonwealth versus Vincent PURDIE. My internet connection froze with approximately 9 seconds left in the Commonwealth's argument. And I just want to make a record that you should rest assured that I heard the entire argument and also have the benefit of my colleagues who were not frozen for the last 9 seconds. So with that understanding, let me turn to this case, which is the Commonwealth versus Andrew J. Medeiros, 2020 P0216. And I will turn to Mr. Gauthier for your argument on behalf of your client.
Thank you, Your Honor. Good morning to the court. My name is Attorney Edward Gauthier. I'm appearing today on behalf of the defendant, Andrew Medeiros. May it please the court. Mr. Medeiros is appealing from a conviction for distribution. The first issue involves the out-of-court statements made by a co-conspirator. We're arguing that these statements should not have been admitted under the circumstances in this case. This was a case where the Commonwealth told the court that it was prepared to immunize the witness. It was collecting signatures to immunize the witness. There was obviously a Fifth Amendment privilege. However, in the trial court, the co-conspirator received the benefit of a 111E disposition. Inexplicably, on the day of trial, when it came time to call this witness, the Commonwealth, irrespective of the immunity issue or the Fifth Amendment issue, simply for unknown reasons decided not to call this witness. Nonetheless, the court allowed statements from the co-conspirator to a police officer that, quote, "I'm meeting my supplier," of drugs, indicating the defendant in this case. These statements should not have been admitted, essentially for 4 reasons. One is that this was a powerfully incriminating statement made by a co-conspirator, not in furtherance of the conspiracy. And there's a long line of cases that distinguish between statements by a co-conspirator that are made in furtherance of a conspiracy and statements of a co-conspirator that are not made in furtherance of a conspiracy. And one type of statement that is not made in furtherance of a conspiracy is when one co-conspirator tells a police officer or someone else that this person, in this case the defendant, is a co-conspirator. Simply,
What's the best case on that point?
the case on that point, Your Honor, is in the brief. I don't have it offhand. I can provide it in a 16L letter, but I do know that that case is in the brief. I believe it is a federal case from a federal court, distinguishing between different types of statements. It's not a Massachusetts case, but it is a federal case.
It's in the brief. No need to submit anything else.
Thank you, Your Honor. Also, not only did it not further the conspiracy, it was made outside the presence of the defendant to a police officer.
But it was made during an attempted buy. So the undercover officer is trying to have the middleman set up a buy with the defendant. And during the course of the buy, the middleman says, he's my supplier, I'm waiting for my supplier. Now, that's a little different than an after the fact statement that something had happened. This was in the middle of a buy, wasn't it?
It was before the defendant was on scene for what the Commonwealth alleges was a hand-to-hand transaction of drugs. It was a conversation in the vehicle between the alleged co-conspirator and the undercover police officer outside the presence of the defendant. He essentially pointed or referenced the defendant and said, this is my supplier of drugs, correct. This raises issues regarding confrontation, and I'd point out that the judge on the record makes clear that this evidence was not credible. I believe she says specifically, this didn't happen. The statement by the co-conspirator pointing to the defendant and saying something along the lines of, this is my supplier. The judge herself found this line of testimony by the officer to be incredible.
Well, I interpreted that as perhaps the language that was attributed to the co-conspirator, not necessarily the content.
Perhaps, but I'm not sure it, in a legal sense, at the appellate review level, it makes that much difference. Although it is important to note that the trial judge was skeptical of this testimony. Regarding the second issue, we had an expert testify to the Commonwealth, and we have 2 issues with that testimony. First, simply is that a lot of it was extraneous, a lot of it was unnecessary, a lot of it went so far beyond the scope of this simple hand-to-hand drug transaction involving trafficking and New York, allusions to other states and allusions to the drug trade.
Before we get to that, though, the Commonwealth's response to you about the my supplier is that, they say that it's irrelevant if the joint venture was available to testify because the statements are non-testimonial. So if we don't agree with you on whether they were in furtherance of the conspiracy, what's your argument that the statements were testimonial?
Well, I don't believe, in order for statements to be testimonial under Hammond or under Gonsalves, there has to be a belief in the mind of the speaker that the statements will be used at trial, or they need to be formalized documents. I don't believe we can make an argument that Mr. Matos, the co-conspirator, when he made these statements, did so in a situation where he had a reasonable basis to believe that they would be used at trial. He, as far as we can tell from the record, he did not know that he was dealing with an undercover officer. However, it's just one of the, I don't know if I would say it's an element. I would say it's more of a factor to consider in evaluating the fairness of admitting these statements against the defendant in these circumstances.
Is there any case that stands for the proposition that the availability of a witness determines whether statements of co-conspirators can be introduced?
There are federal cases that I cited in my brief that use it as an ingredient. It's not a yes or no. It's not automatically out because the witness is available. However, it's an ingredient federal courts have considered among many other factors in making a determination on whether an available witness's out-of-court statement should be admitted against a defendant. In this case, we have a judge essentially saying that it's not necessarily credible. We have a decision on the day of trial, irrespective of immunity and Fifth Amendment issues, that the Commonwealth simply chose not to call this witness. We don't know why. And then it's pretty incriminating evidence. We have essentially an out-of-court statement from a witness who can't be confronted, who can't be challenged on this statement, pointing to the defendant and essentially saying this guy is a drug dealer.
But based on the other evidence, isn't it merely cumulative of what actually was occurring and in form of the actions of the parties?
Well, in this case, there were two separate alleged drug transactions, both of which occurred in very similar fashion. We have the co-conspirator, Mr. Matos, going into the defendant's car. And in one case, there's a transaction allegedly occurring right there. And then in another case, they drive around for a few minutes. But in both cases, the co-defendant or the co-conspirator provides drugs to the undercover officer. But the jury didn't believe all of that evidence. They acquitted the defendant on one and convicted him on the other. And the facts of the two transactions were effectively the same. So
well, I mean, the second one, they drove away for about 10 minutes.
Correct.
I mean, it's reasonable the jury felt that the defendant didn't have the drugs when he arrived there and brought Matos somewhere else to get them. And maybe the jury just figured that didn't constitute his distribution. Whereas the first one, he did it right there, right beside the undercover officer's car.
In both instances, the co-conspirator entered the vehicle without drugs and then exited the vehicle with drugs and gave the drugs to the officer. The only difference is that in the second instance, they drove around. I don't know if we can infer what the jury was considering based on.
I don't think we can.
We don't know. It could have been as simple as some jurors wanted to convict, some wanted to acquit, and so they split the baby and convicted on one and acquitted on the other. It could be as simple as because there was no eyewitness to a hand-to-hand transaction in the second, they simply found him not guilty because they couldn't decide beyond a reasonable doubt exactly how the drugs were distributed. But in any event, the charge in this case was under a joint venture theory, and the defendant moved to dismiss count 2 because the Commonwealth could not prove that the distribution between the defendant and the co-conspirator occurred in Middlesex County because the Olive Garden parking lot is right near the county border. But the judge was very clear with counsel and with the Commonwealth that the theory of this case is not a distribution from the defendant to the co-conspirator. This is a joint theory case where the defendant is being charged with conspiring with under a joint theory of distributing illegal drugs to Sergeant Patterson, which brings us into issue number 3. And the jury instruction was very clear that this was a joint venture theory. The question is, given the evidence in this case, was there sufficient evidence to prove beyond a reasonable doubt that the defendant knew that the drugs he was giving to Mr. Matos, and we will concede that the evidence of distribution from the defendant to Mr. Matos is sufficient. But was there sufficient evidence to prove beyond a reasonable doubt that the defendant knew that these drugs were going to be then distributed to another person? We argue in number 3 that there's just no direct evidence that Essentially the only evidence that my client knew that this was drugs that were going to be given to somebody else is that there was somebody else in the car when Mr. Matos purchased the drugs. So that's essentially the crux of our third argument. And I'd like to briefly move on to the expert. Essentially, the Commonwealth had an expert on drug distribution. As I briefly mentioned earlier, a lot of the testimony really wasn't that germane to a garden variety hand-to-hand drug sale. A lot of it went way out into trafficking and drug enterprises that simply was not relevant to this case. But most importantly, I'd like to focus on the hypothetical question. Essentially, the Commonwealth gave a hypothetical to the expert, who's an expert on distribution, essentially described the facts in this case, and the expert gave a legal conclusion and opinion to 100% certainty that my client is guilty of drug distribution. And
Can I ask you a question about that?
Yes, Your Honor.
We, in other contexts, as you know, experts are permitted to opine that certain conduct is consistent with a drug transaction. And in the hypothetical question, didn't the prosecutor frame the question in that way? That is, are these actions consistent with a drug transaction?
The language in the question wasn't as improper, in our opinion, as the answer. The expert is essentially giving 100% assurance to the jury that what they saw in this case was a hand-to-hand drug transaction. And the evidence was very powerful because you can tell by the fact that they found the defendant not guilty when they didn't have that expert testimony. The second transaction that resulted in a not guilty, the expert really wasn't able to opine as much on that because there wasn't the direct observation by the officer of the transaction. So we say that
I understand your argument on that point, but if we assume that the response was in fact directly responsive to the question, isn't another way to interpret the answer that it was 100% consistent with a drug transaction? A drug deal, as you put it.
I think that the answer in the question can be interpreted generously for the Commonwealth, but it can also be interpreted in the sense that the expert was essentially saying that, yes, this was a drug deal. The hypothetical basically matched line for line with what happened, the testimonial evidence regarding what happened in the parking lot. And then the expert essentially confirmed to the jury that in his training and experience, this was I don't think there's any way to interpret the question and the answer from a juror's perspective other than this is an expert who's done observed drug transactions, and I'm 100% sure that this was a drug transaction. I believe that's a fair inference that a juror would make in this case. I see that my time is running out. If there are no further questions from the panel, the defendant would rest on his brief.
All right, seeing none, thank you, Mr. Gauthier.
Thank you.
Mr. Thornton, when you're ready, you may proceed.
Good morning. May it please the court. I will start with the second issue on the expert witness's testimony because that's what the court was just discussing with my brother. As Justice Kinder's question suggested, the hypothetical posed by the prosecutor was in line with case law here in Massachusetts that makes the presentation of such hypotheticals permissible as long as the quote unquote consistent with formulation is used. And although the
answer, as Mr. Gauthier points out, was, I don't know if what was anticipated or not, but 100% a drug deal from an expert as the response to that question, even though it may be premised upon or prefaced with the word consistent with, does seem to cross the line, does it not?
I would disagree, Your Honor. The expert's response was as the court and my brother characterized it, but the court has to look at that response in the context of the hypothetical that was posed to the witness. The prosecutor was quite careful to pose it with the consistent with language. And I have to disagree with my brother slightly in that with regard to the second transaction, the one that occurred on June 9th, the prosecutor also presented a hypothetical as to that second transaction and also used the consistent with formulation. So the jury did hear the expert witness presented with hypotheticals for both transactions. And each time, while the witness's response was fairly direct and the witness did not state the words consistent with, it would have been clear to the jury that he was responding to the hypothetical posed by the prosecutor, in which the prosecutor said, is this conduct more consistent? What is this conduct consistent with? A person B being a seller, or person A buying from the seller. You know, ultimately, the question for the jury was Mr. Matos, the co-conspirator, selling the heroin to the undercover officer, Sergeant Patterson, or was Mr. Matos getting the heroin from the defendant? And of course, was the defendant participating in a joint venture with Matos to give that heroin to the undercover officer? Given that that was the ultimate question for the jury, it would have been helpful for the jury to hear this expert testimony and to hear the expert's response to those hypotheticals when the jury has to consider, you know, what is going on here? Is Matos attempting to disguise the fact that he's the only one with the heroin and that he's selling it to the undercover officer? Or again, is Matos working with the defendant to sell the heroin to the undercover officer? As for the defendant's other objections.
When I look at the testimony itself, when the prosecutor asks the question the proper way and asks, you know, what the activity described in the hypothetical is consistent with, and then the witness says, 100%, in my opinion, that would be a drug deal. I mean, isn't he then testifying that was a drug deal?
He is testifying that the hypothetical situation was a drug deal. In context, he's not saying that this conduct in this case was necessarily a drug deal. I understand that it's a fine line, and the case law lays out this fine line, but it's clear under the case law that the hypothetical and the expert witness's response falls on the permissible side of that fine line. I'll also point out that in the cases where such testimony has been ruled to be improper and inadmissible, often what we see is the expert witness was a recipient witness in the case. Unlike in our case here, where the expert witness, Sergeant Conant, was not a recipient witness. He had no involvement in this investigation at all. And in fact, he testifies on cross that he hadn't even reviewed the police reports in this case. So the jury heard that Sergeant Conant had no involvement in this case whatsoever. His only role was testifying as an expert witness to explain generally how the distribution of heroin works. And his testimony would have been helpful to the jury. We could debate how helpful. I think it was a relatively minor piece of the evidence against the defendant, but it was permissible. It perhaps would have been preferable for the expert witness, the sergeant, to repeat the consistent with language as provided by the prosecutor. But again, his response within context was that the hypothetical situation was consistent with drug selling, and therefore it was permissible. And
why was it relevant to present expert testimony about going up the chain to find higher level people, and why in particular was it relevant to allow the expert to testify to, you know, this was a $40 transaction, but he's testifying about kilo smuggling, New York, placing that all before the jury?
The relevance of that testimony, I agree, is arguable, but I will first point out that there was no objection on the basis of relevance, and particularly no objection on the basis of relevance to that particular testimony. As we look at the transcript, we see that those particular pieces of testimony that are challenged on appeal now appear where the expert is first introducing his background, his training, and experience. In no place in his testimony does he suggest that the defendant or Mr. Matos or anybody involved in this investigation was involved in trafficking, for distributing kilo weights of heroin, or smuggling drugs from New York or anywhere else. Those specific pieces of testimony may not have been relevant, but they were passing references. Again, they had nothing to do with the facts of this case. They were not objected to. So even if there was perhaps error in the jury hearing that testimony, it would be harmless error. That the court could find that there was no substantial risk of a miscarriage of justice from the jury hearing those little pieces of testimony.
So going to the last issue for a minute, defense counsel was explaining that this was a very specific transaction that was charged to the jury. In other words, that this joint venture theory. Could you give your understanding of this?
Yes, Your Honor. Initially, I would agree with my brother that these indictments were submitted to the jury on two different theories: a joint venture theory and the theory that the defendant had distributed the heroin by selling it to Matos, meaning that the jury could have found the defendant guilty for distributing to Matos, or guilty for participating in a joint venture with Matos by distributing heroin to the trooper. Therefore, the court does need to, as my brother states, find that there was sufficient evidence to support both theories. And here, there was sufficient evidence to support both theories. If we focus on the joint venture theory, meaning that the defendant had the knowledge and intent to participate in a distribution of heroin with Mr. Matos to the trooper, it is a circumstantial case. It does depend upon the jury drawing inferences in the Commonwealth's favor from the evidence, but there is enough evidence there that, when viewed in the light most favorable to the Commonwealth, as the court must view it, that the defendant knew that when he was giving heroin or selling heroin to Mr. Matos, that Mr. Matos would in turn give it to the undercover officer. If the court has no further questions,
So just going back to the first issue then, your learned colleague argues that the statement, "That's my supplier," was not in furtherance of the conspiracy. So what's your response to that?
Yes, Your Honor, there are two statements. The first being when the defendant pulls up, and again, this is at the second transaction, the one on June 9th next to the ice rink. The first statement, when the defendant pulls up, Mr. Matos says, "That's him." And the second statement is that the defendant was, in effect, Mr. Matos's supplier. As my brother points out, there's a question of whether those were the actual words used by Mr. Matos, and I believe Justice Kinder referred to that earlier, but in effect, he said the defendant was his supplier. Now, when viewed in the light most favorable to the Commonwealth, and in the context of the allegation of a joint venture, those statements are both in furtherance of the joint venture, because it's Mr. Matos saying to the undercover officer, Sergeant Patterson, "Yes, this is the guy we're looking for. This is the guy who I'm going to get the heroin from. Undercover officer, you're going to give me your $40. I'm going to take that $40 and then get in the car with this guy, my supplier, get the heroin from him so that I can then give it to you, the undercover officer." And I will point out, as the court knows, the judge has to make an initial determination whether to let those statements in or not. And in making that initial determination, or whether the statements are those of a co-conspirator made during the pendency of a joint venture and in furtherance of a joint venture, the judge has to make that determination and then instructs the jury, as Justice Fahey did here, that the jury has to find by a preponderance of the evidence that these statements were made during the pendency of a joint venture and in furtherance of it. And there was more than enough evidence for the judge to allow the statements in. There was no abuse of discretion by the judge. And then there was more than enough evidence for the jury to then find in turn, by a preponderance of the evidence, that these statements were made during the pendency of a joint venture, a distribution of
So I
heroin.
understand they were made during the pendency. I don't quite understand how they advanced it or furthered it. That's the part that seems less clear to me.
Yes, Your Honor. Well, the time the statements are made, my understanding is that the undercover officer and Mr. Matos are sitting in the officer's car next to the ice rink, waiting for something to happen. They see a car pull in next to them. The defendant was in that car. It was the same car that they had seen a few days earlier for the first transaction. And Matos says, "That's him," in words to the effect of, "That's my supplier." So in the light most favorable of the Commonwealth, the inference is Matos is explaining to the undercover officer, "Here's the guy that we're waiting for. Now I'm going to go get in that car and get your heroin." It may be a small piece of evidence. It may not further the joint venture very much at all, but it is Matos explaining, "Yes, now I'm going to get that heroin for you." Essentially a merchant or a seller saying to his customer, "Hold tight, I'm going to go get your product and I'll be back soon."
So if he hadn't said those words at all, things would have still moved along. So is that a requirement that the words had to have actually advanced the ball, or is it just fine if he's just narrating what he's thinking?
The narration would be enough, although I'm not sure if we have a case on point either way, whether they have to have necessarily advanced the ball or not. They did advance the ball here, perhaps only slightly. But ultimately, the court should remember, too, that even if it was error to admit these statements, and it was not error to admit them, but even if it was, that there was still enough evidence to convict the defendant, and any error would have been harmless, because really these statements weren't telling the jury anything they didn't already know about a joint venture between Mr. Matos and the defendant. If the court has no further questions, I will rest and ask the court to affirm the conviction.
All right. Seeing none, thank you, Mr. Thornton, and thank you again, Mr. Turn to Mr. Hurt for his argument.
We are live and on the record.
Good morning and welcome to this morning's session of the Appeals Court on February 11th, 2021. The next case is Christopher Flagger versus the Commonwealth of Massachusetts, case number 20P0093. I will now turn to Mr. Hirsch for his argument on behalf of Mr. Flagger. Mr. Hirsch.
Thank you, Your Honor. If it please the court, David Hirsch representing Mr. Flagger. This is a case in which I think the two sides pretty much agree on most of the law. It's the application we disagree on. But before I get to that application, there is one legal disagreement that I think I must deal with. The Commonwealth says the standard of review is whether the error did not influence the jury or had but very slight effect. That's the standard for non-constitutional error. Here we have alleged Article 12, 5th, 6th, and 14th Amendment issues, and therefore, as preserved constitutional error, as stated in Yasin, the standard is reversal unless proved harmless beyond reasonable doubt.
Well, on that point, Mr. Hirsch, you refer to it as reserved. It wasn't crystal clear to me that it was. Perhaps you can address that.
It's not a perfect objection, Your Honor, but in cases such as this, particularly where we're talking about objecting to the judge's interference in the case, there's a relaxed standard for what constitutes objection and preservation of the issue by the objecting party. That's shown in cases such as Perez, which I provided to the court in a 16L letter yesterday. I'm presuming the court did get that.
Yes.
And Fitzgerald, cited by the Commonwealth. So as long as—
But doesn't it require, Mr. Hirsch, something more than mere disagreement with the judge's rulings. I understand that counsel would be in an awkward position challenging the judge, but she didn't really ever voice an objection.
Well, I think the statement, I'm trying to, but you keep on interrupting me, crystallizes the problem with the whole case, and crystallizes the whole objection, which is the judge kept interrupting in a way that prejudiced the defense. I think that's enough under Perez and Fitzgerald and lots of other cases.
All right. Well, so assuming you're right about that, let's hear the remainder of your argument.
The various cases on judicial interference cover a wide range of behavior, from Hickman, the Sixth Amendment case I've cited where the judicial behavior was absolutely outrageous, to Meadows, where just about all of the judicial intervention was due to improprieties by defense counsel. This case, I think, is most similar to two others. Sylvester, which I've cited at great length in the brief, and a Sixth Circuit case, Lyell versus Renico, where the court said, as here, the trial judge rarely waited for the prosecution to object before limiting questioning. She instead chose to limit questioning on her own throughout the trial. And here, as we've demonstrated, those interruptions were overwhelmingly when the defense was trying to present its case or when Dr. Kriegman was trying to testify. It would be—
But doesn't, Mr. Hirsch, doesn't the judge has a role of gatekeeper? And it struck me that any of the interruptions or the sidebar requests were to make certain that what the jury or the witness would hear were appropriate questions, or at the very least in the form of a question as opposed to a narrative.
Well, Your Honor, I have several responses to that. First, the issue, as it says in Hickman, is not so much a particular question, a particular answer, a particular objection. The real issue is the extent of it. How much of it is going on? It is the number of times this happened and the manner in which it was done that creates serious doubt as to the fairness of the trial. As to the specifics, first of all, there's the judge interrupting the defense to make what we can only call prophylactic sidebars in case counsel or Dr. Kriegman might, following the interruption, possibly do something wrong. I don't believe that's proper. In other words, when defense counsel asked Dr. Kriegman about his experience at the treatment center, the judge said, "This is going beyond the scope of your questioning." Well, it's kind of hard to have going beyond the scope of the questioning when it's in the midst of the questioning. That really doesn't make much sense. And then at the sidebar, the judge said, "I'm just being cautious. I've had some experience with the witness here." So what we really have here is an interruption on an insupportable basis because of the judge's distrust of the witness. That's not proper. That has nothing to do with this particular case and should not have been inserted into the trial. Dr. Kriegman is a qualified expert. You have other examples, such as when the judge wouldn't let Dr. Kriegman explain his opposition to a diagnosis of antisocial personality disorder, saying, "You've got to stick to diagnostic standards." In other words, what the science says the diagnosis is. There was no basis for interfering at that point. In fact, another one with Dr. Kriegman, the prosecutor first asked Dr. Kriegman about why he about not going to the treatment center. That opened the door. The judge then responded, a couple of questions later, while Dr. Kriegman was in the middle of explaining something else, going back to that with a very confusing direction to him, saying, then when Dr. Kriegman tried to follow that, saying, I'm not going to have you go into an explanation of evaluations for sexual dangerousness. The judge, you were mentioning narrative, Your Honor. The judge, it's perfectly legitimate to say in any cross-examination, now you said on direct, sir, that so forth. Anytime defense counsel tried that in this case, the judge said, is that a question? Well, of course, it's the framing for a question. And in order for any jury to understand what the questioning's about, that's a basic technique for cross-examination. The judge had no business.
I understand, Mr. Hirsch, that different trial judges have different practices when it comes to intervening, but it's not unheard of for a judge concerned about clarifying for the jury to ask what the question is. Now, granted, that was repeated here, but I'm not certain it was inappropriate in every instance.
Well, Your Honor, if it had been once or twice, perhaps it wouldn't have been. If my memory may be wrong on this, I think it was 13 times. Each time, except perhaps once, to the defense. That makes it clear to the jury, this lawyer doesn't know what she's doing. That makes it clear that the judge has lost patience with this particular lawyer, and the jury listening to that is going to think probably, well, the judge is the one who knows what's going on here. Obviously, this defense lawyer doesn't know what she's doing. That is why it's so devastating in a case like this. Our case law talks about how little it takes for a judge to influence a jury through intervention. And it was so much in this case that it could not help but be highly prejudicial to Mr. Fletcher. Among the other things that were involved, the judge wouldn't let defense counsel question Dr. Presiding about Mr. Fletcher's reasons for being distrustful of the NTC program. That was a major one. You have all these things about Mr. Fletcher acting badly, being angry. It was absolutely necessary to rehabilitate him by showing he had reasons for being angry. But anytime defense counsel tried to do that, the judge said, well, since that particular document wasn't specifically mentioned by the judge, it's improper, you can't do that. That's not the way cross-examination works. Under the Tambouille case, a judge may not restrict cross-examination of a material witness by foreclosing inquiry into a subject that could show bias or prejudice on the part of the witness. While a judge has discretion in this matter, he or she has no discretion to prohibit all inquiry into the subject, and all that's required is a plausible showing of bias. That's what the defense presented, and that's what the judge prevented the defense from using. That's
Attorney Hirsch, I don't mean to interrupt you, but you're asking for a new trial, correct?
Yes.
And statutorily, isn't your client entitled to new trial periodically?
Yes, Your Honor. There's a lot of difficulties with how to arrange that. Nobody's really ever figured out how that should work. First of all, the only way to prevent this kind of judicial over-involvement in the future is for the appellate courts to take a stand on it. For that reason, it's very important to have a ruling from this court.
Well, but I mean, he would automatically, I think, annually be entitled to another trial.
No, he is not annually entitled to another trial. That's been rejected by our courts. He has an annual right to petition for a trial, but usually, last I checked, new trials were taking at least 3 years. I don't recall when Mr. Fletcher's next case is. I would not at all be surprised if my brother knows. But the fact that he is entitled to a new trial doesn't change things if he's going to have the same problems in the next trial. And one thing we really don't know is, if this court reverses, does that mean he gets a quicker new trial? I would argue that he should. There is absolutely no case law on the subject. I'm sorry. The cases cited by the Commonwealth regarding judicial intervention, there was both far less intervention and more appropriate, such as in Haley. Several of the questions are characterized by the defendant himself as marginally material, leading, or argumentative. Others largely rhetorical or repetitive. Brown, the judge interrupted the defendant all of 4 times, all appropriately, and only one of the two critical remarks was before the jury. Gallant, defendant was clearly properly disallowed from cross-examining on evidence that had previously been redacted. And in Meadows, we know the judge admonished defense counsel severely for introducing alibi evidence without notice to the prosecution, contrary to agreement memorialized in a pretrial conference report, and many other improprieties. In this case, as in Sylvester, defense counsel did nothing wrong. Now, we know that instructions can be curative, but here, as in Sylvester, the judge's instruction that the jury should not consider any give and take, between the court and any lawyer in determining guilt or innocence could not erase the pervasive impression that the judge disfavored defense counsel. The one other point I'll make about this is, in case there is to be an argument about overwhelming evidence, it can never be overwhelming evidence when there's expert witnesses for both sides. It is not for any appellate court under Roberio and many other cases to determine, well, since we wouldn't have believed witness X, obviously the evidence was overwhelming, and what happened to his testimony didn't matter. That just isn't the law. Finally, Your Honor, I know at least 2 of you have been part of the panels in cases that have denied my argument regarding Hunt and similar cases. All I can say right now is this cannot be an unfounded extension of Hunt, because there's no other way to interpret it, because Hunt cannot logically be limited to just whether empirical evidence is needed just for treatment. Thank you. If there are no further questions, thank you, Your Honors.
Thank you, Mr. Hirsch. And we have read closely the second argument on the last point that you made in your brief. So rest assured, we will consider that carefully.
Thank you.
Mr. Mansfield, when you're ready, you may proceed.
Morning, Your Honors. May it please the court, Brian Mansfield for the Commonwealth. At the outset, Your Honor, I would disagree with Mr. Hirsch's assertion that this is a constitutional issue. In Mr. Fladger's brief, they claim there's been a violation of the 6th Amendment. This is a civil case. It is not a criminal case. The 6th Amendment only applies to, or Article 6 only applies to criminal cases. That being said,
although we treat these cases as criminal in many other respects, do we not?
In some respects, but, you know, with some of the protections, the burden of proof, who has it, and what the Commonwealth has the burden of proof, even though Mr. Flagger was the petitioner, the standard is beyond a reasonable doubt. So in some aspects, they are treated in some ways like a criminal case, but in the Commonwealth's view, that doesn't take this to every aspect make this a criminal case. It's still considered a civil case. Section 9 says that shall proceed as a trial as a civil trial. So in that aspect, again, I don't believe this is a constitutional issue has been raised.
So you don't think the confrontation clause would apply in this case?
Certainly,
For example, the
Mr.
interference with the right to cross-examine and confront.
Certainly,
witnesses.
Mr. Flagger has a right to cross-examine, and he did cross-examine quite extensively. So I do agree that Mr. Flagger has the ability to cross-examine the Commonwealth's witnesses, which he did extensively. But Mr. Flagger has not offered any reason for this court to overturn the jury verdict that Mr. Flagger is a sexually dangerous person. There was, the judge did interject herself into the trial at times, which is perfectly appropriate. At no time was she disparaging to Mr. Flagger's counsel. She was not partisan in any way. She did not act as an advocate for the Commonwealth. She did not question Mr. Flagger's expert's witness credibility. Throughout the trial, despite the questions she asked and the interruptions by asking counsel whether there was a question, asking her to let the witness complete an answer, or saying that the question was asked and answered. Throughout that time, the judge did nothing but act as an impartial arbiter, which these cases...
Do you, Mr. Mansfield, do you disagree with Mr. Hirsch's observation that the intervention by the judge was one-sided in that counsel for the Commonwealth was not interrupted or asked to come to sidebar in the same way?
The Commonwealth certainly was not asked to come to sidebar or had the same type of comments from the judge, but the Commonwealth's questions, in each of the cases that the judge interrupted the defense counsel, it was because there was not a question before the witness. There was a statement of fact with no question embedded in it. It was a question that had previously been asked. The counsel had cut off a witness before they had completed their response. The Commonwealth's attorney at trial did not follow the same conduct. The Commonwealth did not have repeated instances of just making statements without a question. The Commonwealth did not repeat questions. The Commonwealth did not cut off the answer of an expert. So although the number of interjections was much higher for the Mr. Flagger, it's because of the type and clarity of the questions and the manner in which the questions were asked by defense counsel or by Mr. Flagger's counsel that called for those.
Do you disagree with his count where he says it was sua sponte interruptions were 74 times in total, 66 towards the defendant's counsel and 8 towards the Commonwealth?
I believe that those numbers are fairly accurate.
So that's like an 8-fold difference, right? I mean, 66 is 8 times 8 plus 2. I mean, should the judge have done something else? Like as frustrating as it might be, if this is happening, maybe take a break and explain to counsel what the problem is, or if the judge says at one point, I've got experience with this witness, well, so you deal with that before the witness is ever before the jury. I mean, at some point, should we have a concern about this?
I think the concern is that Mr. Flagger's counsel did not learn at all and did not change her manner of asking questions after these interjections by the judge. One would think that having been told, asked, is there a question after making a statement of fact rather than a question, counsel would ask questions appropriately after that. But what happened in this case was Mr. Flagger's counsel continue to ask or continue to behave in the same manner by making statements, by interrupting, by asking questions that had already been asked and answered. So
here's my question though. How are we supposed to figure that out on a cold transcript? Because I could make this is why trial judges have the power to make credibility determinations, because I could make the statement, you stole my money, right? You stole my money. You stole my money? Like, we can't tell. A statement of fact can be a question based on the inflection of the person's voice, but we won't be able to figure that out from the cold transcript.
Well, I think in many instances you can tell that from you certainly don't get the inflection, but the type of the question. I mean, there were times when Mr. Flagger's counsel started a statement and said, "Oh no, I'm wrong about that," and then the judge would say, "Is there a question?" or make some kind of a statement that was clearly not in the form of a question. So again, I think it's incumbent upon counsel to take the cues from the judge's lead and to retool how she questions or the manner in which the questions were asked. And at sidebar, there were certainly times when the judge did try to direct counsel and how to do it properly. Unfortunately, counsel just continued to make the same type of mistakes, for lack of a better word, as the trial went forward. And I would note the SJC has rejected the notion in the past that the sheer number of interjections required reversal. That's the Rivera case, 441 Mass 358, when there was a great number of objections or interjections by the judge for many of the same reasons here. And in this case, Mr. Hirsch brought up a couple instances with Dr. Kriegman. Two of them were the judge. This is a highly experienced judge, particularly in the SDP session, who had seen Dr. Kriegman testify multiple times, where she interjected and called a sidebar to prevent Dr. Kriegman from making references to prior Section 9 hearings for Mr. Flagger, or the fact that somebody, a petitioner like Mr. Flagger, has multiple Section 9s. Mr. Flagger had brought a motion in limine to exclude that testimony. It was excluded, and so the judge was really, for the benefit of Mr. Flagger, was interjecting in Dr. Kriegman's testimony in those two cases to prevent him from opening the door that Mr. Flagger has had prior Section 9s and will have prior Section 9s.
But why not while the jury's there? Why not do that while they're out and before the witness even starts testifying?
I believe it was based on the way Dr. Kriegman started to testify in his responses to the questions that led the judge to note that this is where this might be going. She did do it out of the jury's view at sidebar, except for some questioning to Dr. Kriegman directly to make sure he was clear as to what he should and should not say. But again, that was to Mr. Flagger's benefit. It did not prejudice him in any way. In fact, he would have been prejudiced had Dr. Kriegman, in fact, opened the door. Dr. Kriegman's response to why he did not diagnose Mr. Flagger as having a conduct disorder before the age of 15, there was an objection. It was appropriately sustained because Dr. Kriegman's response was completely unresponsive. He started to talk about the reliability of diagnostic systems. He didn't talk about his own opinion or why he did not find Mr. Flagger met that criteria. And then briefly, as far as
turn to the Hunt issue, I am not crystal clear. Do you think that this objection about the judge's sua sponte interruptions was preserved, or do you think it was not?
I think the only one that was, I believe, could be considered preserved was the cross-examination on bias with Dr. Peretti, which is subject to a roughly 43 pages of the transcript on that sidebar, where the judge tried to direct the attorney and allow her to make the point she wanted to make, but she wanted her to actually connect the dots. So I believe that one was preserved. Again, when you look at the transcript, it's pretty clear that Mr. Flagger was conflating review of the records with reliance on a particular record. And all that happened at that sidebar was the judge tried to guide counsel so that she would question and establish the fact that if there was a particular document that she believed the doctor misread or did not take into consideration, that she asked her, did you rely upon this? But counsel did not do that. She only wanted to establish that, they had been reviewed, but review and reliance is two completely different concepts. So, and it's clear from that sidebar that counsel would have been allowed to make the point she wanted to make the point had she simply connected the dots to make the issue relevant, but she chose after that sidebar not to do so. And as far as the argument on sexual sadism, the doctor's opinion was completely supported. She relied on the diagnostic and statistical manual. The Hunt case, as this court has found on at least 2 occasions in the Laflamme and the Tyru cases, does not extend to every piece of the expert's testimony. In this case, though the expert was relying on her expertise in the area, her knowledge of the diagnostic and statistical manual and the criteria, and most importantly, the jury could not have found Mr. Flagger sexually dangerous based solely on the diagnosis of sexual sadism. The witness that testified to that effect was the representative of the Community Access Board, and the jury was instructed that in order to find Mr. Flagger sexually dangerous, they had to credit at least one of the qualified examiners that Mr. Flagger had a mental condition that made him likely to reoffend sexually. And both qualified examiners had found that Mr. Flagger suffered from a statutorily defined personality disorder, as did the cab representative. So the jury is assumed to have followed that instruction. And if there are no further questions, the Commonwealth would rest on its brief.
Very well, seeing no questions, I want to thank you, Mr. Mansfield, and also you, Mr. Hirsch, for your
3814 appeals law. It ends up saying on the 4th section that if you include anything that's not in the record, that you'll be charged the expenses. And I tried to include additional evidence, and as noted in the sanctions motion, the DCF worker or the lawyer ended up misrepresenting the record to prevent me from including the additional evidence. And by doing so, it ended up that the record was, from my point of view, completely false, the majority of it. And the idea that, like the DCF worker, there was no option to say, well, can this be recorded? When
you say there was no option to say, can this be recorded, do you mean that night of the alleged incident?
No, I'm saying when the DCF worker called me. She was not able to investigate me in person because I was in California. So she did it by phone call. And actually the first phone call I was driving, so I wasn't able to talk with her. And she made a lot of decisions right after that first conversation where I wasn't even able to make any argument at all. And according to the record, she never gave me a chance to explain what really happened. And so I just, it's hard for me to make without going off record, it's hard for me to make the proper argument. But I just think that, it's basically hearsay of what she ended up saying or alleges I ended up saying.
So to be clear though, were you given the opportunity to testify at the hearing?
Yes.
And you had the chance to be able to say to the hearing officer what you wanted to say?
It's hard for me to really remember on that point. I believe I did say, I was able to say some, yes. Part of it.
And Mr. Waters,
go ahead.
Did that include some of the background information that you said you wanted to offer?
I guess I should have. I was not quite prepared for this. I do remember, yes. I guess I did say my point, a lot of the background, and maybe it wasn't complete. And actually, okay, I guess there's another element. The email, which we were not aware of an email that was used on, I believe it was page 33 of the administrative record. It's in it wasn't in the appendix for this case, but it was, well, actually it's mentioned in my brief. That was my judgment on the pleadings brief. And on the email, which was, I believe, 33 of the administrative record, I ended up including 2 attachments. And one of the attachments was of the cabinet that my Samantha Cardin told the DCF worker was never in the kitchen. And I sent the DCF a picture of the cabinet in the kitchen with metadata. And they decided to, they did not inform us before the administrative hearing that they were that email existed, or that they, were including it in any way, shape, or form. And we only found, my lawyer was not aware, and it was only included after the fact. I guess I can yield.
Well, we want to make sure you have a full opportunity to tell us whatever you want us to consider. Justice Henry.
Did you end up being criminally charged for the events of the evening in question?
No. Well, I was charged, but the charges were dismissed.
And am I correct that you had originally subpoenaed the mother to the first hearing date, but you did not enforce that subpoena as to the second hearing date?
Yes. She was still supposed to show up, but she did not show up. And there was a long debate about what should have happened, where the DCF worker said that I would have to bring a file in Superior Court to enforce this subpoena. And she said that I could not, that she did not have any power to enforce the subpoena. And yeah.
And what impact has this finding in the hearing had on you?
I mean, with the fact that DCF has, I'm not willing to go to the courtroom and deal with DCF making allegations based off a bunch of hearsay. It's just the idea, like the DCF said that they wanted me to do a battery program, and I'm already suffering, significant distress from these allegations. And the idea of going to a battery program and sitting down with a bunch of actual woman abusers, it would not be good for my mental health. And I'm not willing to do that. And I'm not willing to face DCF in a courtroom. So it's completely kicked me out of my daughter's life. And yeah.
Mr. Waters, I take it you're not living in California now?
Correct. Currently,
do you reside in the...
My mailing address is there because of, I don't know if it's all right to go. because of a lot of death threats up in Massachusetts, I'm actually staying down in Florida. But
I see. So, Mr. Waters, I just want to make sure you understand that you won't be able to reserve the time after you complete your argument. So we want to hear everything that you have to say.
Well,
on the other hand, we're not forcing you to continue if you choose not to.
yeah, I mean, I guess, well, as far as on the due process, where it's just like I put in the brief, there's, I mean, no, whenever there's money involved, cameras or recordings are included, whether it be a bank or whether it be usually most stores or even, as I put, poker games. And the idea that, and you know, our president has been notoriously stated for misrepresenting details and lying, or ex-president, on several occasions. And so they, you know, humans these days, like, facts seem to matter less and less as time has gone on. And in 2020, it seems that, or 2021 now, the dishonesty is just extreme, where people, if you say something enough times, people just believe it. And it doesn't really matter whether you present evidence or not. And so it's disgusting to say that, you know, because one lady decided to make a bunch of allegations that I said various things. And actually, like, I mean, one example, I mean, she said that, which I guess I didn't present it, but in the record, she ended up saying that the reason why I broke up with my ex-girlfriend was because she shaved her crotch or lower area. And I mean, that's just like, that doesn't even make sense. Nobody would say that ever. Like, so the idea, so I believe the reason why she put it in there was just to make me look like an animal, for lack of a better word. But it's just ridiculous to think that somebody would say that. And there was also, but yeah, I guess I will yield to that.
All right, any further questions? All right, seeing none, thank you, Mr. Waters. Mr. Batchelor, when you're ready, you may proceed.
Thank you, Your Honor. Good morning to the court. My name is Andrew Batchelor, and I'm here on behalf of the department. This is a very narrow appeal. Mr. Waters raises numerous arguments just now during his share of time that are not in his brief and not properly before the court. And I won't belabor those issues, other to say that.
I'll pause you on one of them because I didn't follow. So if you could walk me through. I mean, he definitely seems to have raised the hearsay question. I saw it at Record Appendix 15. Do you agree that was preserved?
It was preserved to the extent he's asking for a blanket rejection of allowing any hearsay statements from department employees. That's his essential argument on appeal. There's no dispute that hearsay evidence was considered by the fair hearing officer and coming to the fair hearing officer's finding of facts. What Mr. Waters is now arguing is essentially goes to the weight of that evidence, but he's in his brief, he's saying that there should be a blanket due process rule prohibiting the admission of any written statements from department employees. And so to the extent that's his argument, he's preserved that, and it's not supported by the law and should be rejected.
Okay, and then his constitutional argument, I guess, again, I'm just trying to follow the chronology here, because it seemed like he had moved to amend to assert the constitutional violation, like he just checked the additional box on the form, and it seemed like that was before the hearing officer's decision. But if I've misunderstood the record, I guess I'd like to understand that.
My understanding is that, yes, there was a move to amend it to make a constitutional argument, but there was no flushed out constitutional argument. And
Okay.
Mr. Waters did not, unfortunately, include the transcript of the fair hearing. So the record does not show what he actually argued, but there is the decision from the Superior Court, and this due process constitutional argument was not raised at the Superior Court. So there was mention of a constitutional argument before, but I would suggest not articulated in a way, at least not available in the record, to suggest that this type of argument had been made previously.
So he seems to be arguing that with stakes as high as they are, if a department social worker is going to say in a report that a parent said something, that communication should be recorded. What do you say to that?
That is I'd say two things. One is that's an argument that goes to the weight of the evidence that he could make to the fair hearing officer and say, you shouldn't trust non-recorded statements from department employees. And that is something the fair hearing officer could consider. As to a rule of evidence, as to whether or not the rules of evidence should be changed such that there are new requirements for the admission of statements from department employees, there's really nothing to suggest that we should have such a drastic change from Covell, which I cite numerous times in my brief, makes it clear that hearsay evidence is admissible in written form, and there's no basis to change that existing rule. And I would leave it at that, Your Honor.
Do you think that adoption of Luck and adoption of George about the admissibility of hearsay and termination of parental rights cases have any bearing here?
I don't believe so, Your Honor. I've read them, but I'm not, the bearing is not immediately transparent to me as you ask. The hearsay statements that were admitted here were included the personal observations of the department worker. So in the decision, that there's particular emphasis placed on the department worker making her own observations about bruising on the mother's face, and so that's sort of a direct personal observation from the worker that came through in hearsay. So I don't believe there's a direct application for Luck and the other case that you mentioned, Your Honor. But at least I'm not seeing it right now. But again, this is a very narrow issue, and the lack of raising this before the Superior Court, the lack of a transcript, which is, as the court is well aware, is not a minor requirement, but is an absolute requirement. If you're challenging the sufficiency of the evidence, which at the end of the day, this challenge is, the constitutional challenge is only the first step. There would have to follow that the remainder of the evidence after the hearsay is excluded on due process grounds. The question is the remainder sufficient, and because there's no transcript, Mr. Waters can't make that argument. And when it comes down to what due process is, that's about the notice and opportunity to be heard, not evidentiary standards. And so there is no question that Mr. Waters received due process here. And returning to the beginning, the standard for admitting hearsay evidence under Covell applies and should not be changed. And unless the court has any other questions, I will rest on my brief.
All right, seeing none, thank you, Mr. Batchelor. Mr. Waters will now take the matter under advisement. The case is, and then I will introduce the case by name and case number, and then I will turn first to Mr. Sorcinelli for his argument.
And we are live and on the record.
Welcome to this morning's session of the Appeals Court on the 11th of February 2021. The next case on the docket is 2020 P359, excuse me, Antonio Sorcinelli versus Danielle Sorcinelli. Mr. Sorcinelli, when you're ready, you may proceed with your argument.
Hi, my name's Antonio Sorcinelli. I have 3 children, Tanner, Gia, and Tucker, who live with me the majority of the time in West Springfield. I've been self-employed the last 19 years as a landlord, and I'm frequently in court for evictions, and I've always felt the system is fair if you follow the law. I feel I was not treated fairly and the law was not followed in my divorce. I'm going to do my best to explain the areas where I believe Judge Randall made it. At the status conference, just 3 weeks before trial, it was stated repeatedly that due to our signed agreement, custody would not be an issue at our trial. The transcripts show 9 times the defense stated custody would not be an issue at trial. And the summary of this is on page 6 of my brief. More importantly, you will see from the transcripts that the judge stated, and I quote, representations have been made to the court. I know that counsel is well aware representations made in court can be binding. And as far as I'm concerned, it's not a custody case. Despite this, the defense showed up to the first day of trial with a proposed parenting plan seeking sole legal custody. This is volume 3, page 97. In our case management in May 2016, the defense was seeking shared legal custody. In the defense's proposal to the GAL in 2017, the defense was seeking shared legal custody. In our signed parenting plan, we agreed to shared legal custody. In our status conference, just 23 days before trial, the defense stated that shared legal and physical custody would not be disputed at trial. The court stated that custody would not be an issue.
Did you raise this issue with the trial judge on the beginning of the trial?
Yes, and I also filed written motions seeking to introduce additional evidence when the judge decided that it would be an issue for trial, and both of those motions were denied.
All right, and the discussion on the motions and the raising of the issue before the judge, was that on the record?
Yes, it was in court, yes.
And is there a copy of that record that's been provided to us?
No, Your Honor. I tried to get the transcripts and it was a 5-day trial and I couldn't afford them. I was on Mass Health at the time, and I thought that made it, that the state would pay for the transcripts, but the judge denied that. I appealed, and that got denied as well. So I tried to provide the transcripts, and I wasn't able to. But there is a written motion on the record of asking for rebuttal to introduce rebuttal evidence.
So counsel on the other side argues that you also filed a proposed parenting plan right as trial was starting, and points to the addendum to the appellee brief at page 57. Did you file your own proposed parenting plan?
Yes, the proposed parenting plan that I proposed was also that is accurate. And it was only if the judge wasn't going to allow our signed parenting plan. I was going back to what we started with at mediation after the judge said that custody was going to be on for trial. I showed my own parenting plan, but requested that what we signed in mediation be adopted. At the status conference, I filed a motion just asking the judge, hey, I want to know that this isn't going to be an issue for trial. Can you please adopt this? And she didn't allow my motion to adopt it as a partial, agreement into the divorce, but she also said that it would not be an issue at trial.
So originally the trial was supposed to be 2 days. It became 4.5, and there was a fair amount of time between some of the trial days. So is it fair to say you had some time to adjust in terms of whether the fact that this seemed to be litigated custody?
Well, I couldn't introduce new evidence. All the evidence had to be submitted before the trial. So regardless of how long it went on for, I couldn't change that portion.
The judge made comments about the custody not being an issue, as did counsel, based on the mediation and the expected second day of mediation, which occurred after that court hearing, isn't it?
Yes.
So it's unclear what happened there at the second day, because the judge fully agreed there were details that needed to be worked out, and was reluctant to accept anything that had been proposed until all those details were worked out. So,
Yeah.
So is it fair to say that things did not go well the second day?
Well, the second day of mediation was solely, finances, working out child support. And no, that did not go well. We weren't able to agree. So as a punishment, they came to court seeking sole legal custody.
I guess what we're trying to understand, though, is when you say you weren't able to agree after the end of the second day of mediation, what regarding custody were you not able to agree about?
Oh, nothing. We had the first day of mediation, we reached a signed parenting plan. We both signed it. It's in evidence. It's in the appendix. We signed it, and all I wanted was for that to be adopted. When it wasn't, she came to court. I was hoping that the judge would just say custody is not going to be an issue, but the judge did make it an issue. So I had my original parenting plan, and they had their original parenting plan. And, the judge did not agree with me that custody should not be an issue at the trial.
And we don't have a record of that discussion.
But the judge, you can see in the court's rationale that the judge did allow custody to be an issue. And we do have the transcripts from the status conference where the judge said that it wouldn't. There are some transcripts on the record that you have where the judge said it wouldn't be an issue. And in my appendix, volume 2, page 146, the judge did allow custody to be an issue. And I believe that was an error that prevented me from having a fair trial.
When did the judge tell you that? When did the judge not enter the order?
On the very first day of trial. When did the judge not enter the order?
The parenting order, yeah.
Oh, at the status conference, I filed a motion wanting that to be a part of the judgment, and the judge denied that. But at the same time, she said custody will not be an issue in this case. The defense said that 9 times. If you look on page 6 of my brief, you'll see 9 times where the defense said it would not be an issue, would not be an issue, would not be an issue. And the judge allowed it to be an issue.
But we don't know why. We don't know why.
I guess that's true. We don't know why.
But I'm assuming it was discussed in court.
I asked for it to be entered in court, and the judge said, proceed with your testimony. This is, we'll let it hash out. And so, it went from 2 days to 4.5 because, this was like a 2.5-year trial. I had to go over all the custody issues that we had already gone over with the GAL, in mediation. I spent 2 days up there fighting for what we had already agreed to. And the judge blamed me for it completely. When I feel like she just should have said, I already said in the status conference hearing that custody would not be an issue. So proceed with the other issues. That's already decided.
But my understanding was that at the time that she said she wouldn't enter that order, she said the devil was in the details and all the details had not been worked out.
I mean, you can read the signed parenting plan for yourself. I mean, there was some very minor details in there. I guess she wanted us to, you know, to try to work everything out, but we did have a signed agreement for custody.
Do you know the page references in the record for that?
Yes. Okay, yeah, it's volume 3, page 101 is the signed parenting plan that we signed in mediation. Can I continue?
Please do.
Okay. I'm going to skip ahead. So that's my point number one about I feel like I wasn't given a fair trial because custody wasn't supposed to be an issue, and it was. And even without the transcripts, I feel like I've proven that based on what was said at the status conference and what the judge said in her rationale. The second mistake that was made was the way my income was manipulated. In the beginning of the divorce, the defense's child support guidelines that they prepared indicated my income was $40,000, and that's docket number 30. This changed after the GAL's recommendation were made, giving me more custody than the defense wanted. The initial temporary orders, docket 27, gave the mother majority of custody. Weekends were split, and the mother had 3 school days, and I had 2 each week. And I was ordered to pay $150 in support in the beginning. Now, after our trial, the custody was reversed. Now, I had the majority of custody and was responsible for 3 school days each week. Yet my child support went from $150 per week to $460 per week. The message to me was clear. If you want to fight for your kids, that's fine, but you'll be punished for it. We'll give you the majority of parenting responsibilities if you want them, and we'll triple the support you pay. It doesn't make sense to me. I believe I'm the only person to ever come before this court that has the majority of custody and is still ordered to pay the other support. Now, the defense hired a financial expert for trial. His report, volume 1, page 503, you will see that all the figures he uses lines up exactly with the figures in my tax returns, which are all included in volume 1 of the appendix. You will see he arrived at the income the defense wanted simply by deducting out all of my legitimate business expenses. The appeals court noted in Wellen versus Wellen, in determining income from self-employment, a judge must determine whether claimed business deductions are reasonable and necessary to the production of income without regard to whether those deductions may be claimed for federal or state income tax purposes. As further direction, the appeals court noted in an unpublished decision, Zofrio versus Zofrio, the fact that a parent is permitted under the tax laws to deduct an amount for depreciation does not mean that those funds, which are not out of pocket, are not available to pay child support. So if I purchase a rental property for $100,000, the tax law allows me to expense that purchase price over 27.5 years. So every year on my tax return, there's a depreciation expense for this. Now, the appeals court has already ruled in the case I just cited that even though it's allowed for tax purposes, it's not allowed for child support purposes. And I understand that, and I don't dispute that. But with the same reasoning, the full amount of my mortgage payment must be allowed as an expense for the purposes of child support, as it absolutely is an out-of-pocket expense. Now, for tax purposes, I'm only allowed to deduct the interest portion, and the expert only gave me a deduction for the interest portion. But the appeals court ruling that I just stated talks about out-of-pocket expenses. Now, I'm a landlord where 100% of my income comes from rental income. I absolutely must pay my entire mortgage to stay in business. Money used to pay these mortgages is not available to pay child support. The defendant had her own rental income. And in her original financial statement to the court, docket 28, the defendant lists her own mortgage principal as an expense. Now, her attorney only stopped doing this after realizing I had much more mortgage principal than she did, and it would be much better for them.
Mr. Sorcinelli, I'm sorry to interrupt, but I see that your time is up. I know you may not have reached everything in your brief, but I assure you that we have read your brief very carefully and will take all the arguments into consideration.
Thank you, Your Honor.
Thank you. Ms. Fitzgerald, when you're ready, you may proceed.
Thank you, Your Honor. If it pleases the court, my name is Stephanie Fitzgerald. I'm representing Danielle Sorcinelli, the appellee in this matter. In addressing, Your Honor, the points made by Mr. Sorcinelli and his brief and also today, the fundamental problem we have is that we don't have a full transcript and record of the trial court proceedings. Many of the arguments that are made are dependent upon review and understanding of what happened at the trial and whether the findings of the court are an abuse of discretion or not supported by the evidence that was presented at the time of the trial. I'd like to address the issue first of the surprise. The status conference in July, at the status conference, Mr. Sorcinelli is correct that he brought a motion to enforce an incomplete memo of understanding that the parties had negotiated in a mediation session. And as is the role of the trial court judge in the probate and family court, the judge has the discretion as to whether to accept that. The judge also has an independent obligation to find that the agreement is fair and reasonable to the parties, as well as appropriately makes provisions for the minor children. For a variety of reasons, the judge denied that motion, and Mr. Sorcinelli was on notice as of that date, July 30th, that his efforts to enforce that agreement, that incomplete agreement, were unsuccessful. And at that time, there was a discussion on the record about minimizing the trial days, and it's Mr. Sorcinelli who insisted on maintaining the 2 full days. In addition, Mr. Sorcinelli
he says that the evidence was fixed because it had to be provided in advance, and so he couldn't add evidence on this point of custody at this late date. Is that correct, or is that
is? Thank you, Your Honor. I'm sorry. That is not correct. The exchange date on the exhibits, and there's ample discussion in that transcript about the day to exchange exhibits and whether it should be before the second mediation date, because if issues are resolved, then those exhibits wouldn't be necessary. If it's going to be after the second mediation date. So the exhibit exchange was after the July 30th date, and it was before the trial. In fact, Mr. Sorcinelli provided over 130 exhibits to me, the majority of which were custody related. And he also, at that exchange, provided the proposed parenting plan that indicated that he was intending to challenge physical and legal custody. And I also exchanged my parenting plan that maintained physical custody, joint physical custody, and asked for ultimate decision-making for Mrs. Sorcinelli if the parties could not agree. So it's Mr. Sorcinelli who presented and would not limit the amount of trial time or the issues presented. And he was on notice of this on July 30th, as well as it had ample time to provide multiple exhibits and utilized as the plaintiff 2 full days in presenting evidence on physical and legal custody.
On the biggest picture issues, how was the judge's order on custody? How did it differ from this order that both parties signed, or this agreement, I should say, that both parties signed, but then didn't get entered?
So she did order joint legal custody, Your Honor. So Mr. Sorcinelli ultimately was successful on that issue. In her rationale, she expressed concern about the party's ability to make decisions, and characterized Mrs. Sorcinelli's concern about joint legal custody as being understandable, but referenced that she wanted to give the parties the opportunity to co-parent and make joint decisions once the conflict of the divorce was behind them.
But I don't know if you answered the judge's question, counsel. She wanted to know how the proposed plan that was submitted for acceptance in July differed from the judge's ultimate plan.
On legal custody or on the parenting plan?
Well, was there a huge, and I think I don't mean to step on Judge Henry's question, but
that's okay.
I understood her question as there was a proposed plan that had been agreed to at the first day of mediation. A plan came out, and whether it's parenting or custody, but the custody issue came out after trial. How was that different than the proposed plan that the parties had agreed to at mediation? Was there a big change from what the judge ruled on as compared to what the parties had originally agreed to at mediation?
Okay, so I would say that it was not a big change, and I would also say that that my client wasn't seeking a big change. So on legal custody, the court ruled granted joint legal custody, which was the same as the memo of understanding. And with regard to the parenting plan, there's still a shared physical custody arrangement. The transition times on certain days are different, and the judge ordered some different times and some also different obligations with regard to transportation. But the judgment of divorce is not far from the memo of understanding.
Did it go, it seemed to be that he thought it was going to be 60-40 and it became more 50-50, or what did it end up becoming?
Oh, I disagree with that in that characterization. The parenting plan in the agreement has the parties, the big difference of the disagreement was the exchange time on Wednesdays and the exchange time on Saturday nights. So the parenting plan contemplated by the memo of understanding had dad had Sunday morning through Wednesday, and mom had Wednesday being the exchange date to Saturday morning, and the parties were exchanging Saturday nights. And the difference of opinion really was on what the appropriate exchange time was on Saturday versus and Wednesday. And Mr. Sorcinelli, what ultimately happened, Your Honor, is that we post-judgment entered an agreed upon judgment motion to modify. So Mr. Sorcinelli has Wednesday during the day with an exchange after school, and my client has Saturday evening with exchange after dinner. So it's really, it's a matter of hours on the exchange date. It was never 60-40. And I think that's the fundamental issue here, is that Mr. Sorcinelli believes that had the exchange time stayed with my client having the children transition on every other Saturday morning, he would have had more than 50% custody, therefore would not have been obligated to pay child support. The slight differences in the parenting plan, Your Honor, still qualify the parents as joint physical custodians. And the basis for the order of child support is the difference of the incomes of the parties. And consequently, it's a joint income child support case. But because of Mr. Sorcinelli's self-employment income and my client's income at the time of the divorce, there's still a child support order. So, Your Honor, going to the issue of the amount of time and the rebuttal evidence that Mr. Sorcinelli had raised in his brief. This is a case that was originally scheduled with all issues in for 2 days. It was expanded by the court to 4.5 days. And without the transcript, there is no ability to determine whether the judge's limitations on the time and the rebuttal and the cross-examinations was arbitrary. And it's well supported in the case law that the judge has an obligation to maintain orderly adjudication of a trial and keep the trial moving, and that it's within her discretion to set reasonable limits. The issue with without having the transcript is there's no ability to determine if the limits were arbitrary, and I would say that they were not. That Mr. Sorcinelli had the majority of the 4.5 days of trial time for his case. And with regard to the issue of the rebuttal evidence, Mr. Sorcinelli referenced that he was precluded from providing rebuttal evidence on this new issue of custody. Your Honor, the rebuttal evidence, to my recollection, was in the majority of financial, and that Mr. Sorcinelli's, the majority of Mr. Sorcinelli's case in chief evidence was on custody. So the issue for, and it's well within the court's discretion to allow rebuttal evidence or decline it, or unless the rebuttal evidence is one that the proponent has a right to introduce, and that being evidence that is related to specifically rebutting a new fact in the opposition's case. Without a transcript, we can't determine that.
Was there a discussion at trial as to like an offer of proof of the rebuttal evidence, what it was intended for use? Did he generally discuss that at trial on the record?
Your Honor, there was no, to my recollection, and please, this being in 2018, to my recollection, there was no offer of proof. It was a binder of documents that were primarily financial in nature.
But he asked the judge to be allowed to introduce these documents to prove certain aspects of what he was trying to say.
Correct.
And we have no record of that.
Correct. And the issue, my understanding of the denial of the motion to allow it is based upon the fact that they were duplicative of materials that were already in evidence, or that were able to be introduced in the case in chief and directly related to his business finances. So consequently, there was no reasonable basis for having withheld them, and there was no basis for failing to provide them to opposing counsel within the document exchange that was prior to trial.
So let's go to his argument, though, that the full amount of his mortgage payment should be an expense that has to be allowed. What do you say to that?
Sure. I would say that it's wholly inappropriate. When you pay a mortgage payment, you're paying part of interest, which is the cost of the loan of the money, and then you're paying principal. And he wants to reduce his income by the principal payments. You're not allowed to do that for the IRS, and you're not allowed to do that for the probate and family court, because you are reinvesting that property into your own pocket. You are increasing the value of your business. So you're basically paying yourself back. It's increasing the value of the assets. So to reduce your child support or your business income by your principal payments, you're basically reducing your income for money that you're giving back to yourself and increasing your net worth. So I have never seen a case where that has happened.
I think his point is that money is being paid somewhere. It's not that it's just readily available. And your point is that doesn't matter, because what you're really doing is creating an asset, and you can't use that decision to shield the money.
Correct. And that also flows into the judge's findings with regard to the changes in his business practices and the reinvestment of increased amounts in capital improvements that benefited him on his asset picture, which
So
was a
basically,
departure from.
The idea was he changed how much money he was putting into the rental properties to either maintain them or to make them nicer?
Yes, there was a change in the business practice, and we had in the record prior tax returns, and there was a significant increase in the amount of capital improvements that differed from his business practices in the past, and that went to his sole benefit, having already stipulated relative to the property division in the case.
And had this been testified to by the expert?
Yes, and my client, and on cross-examination with Mr. Sorcinelli.
And we have no record of that.
No.
Thank you.
Thank you, Your Honors.
Seeing no further questions, I see your time has expired. Thank you for your arguments, both of you. Mr. Sorcinelli, let me just explain briefly what happens from here. We're not going to make a decision immediately. We will discuss the case, and you will receive a written decision, hopefully in the not too distant future.
Thank you, Your Honor. We are live and on the record.
Welcome to this afternoon's session of the Appeals Court on the 11th of February, 2021. Our next and final case for the day is 2020 P454. That's East 4th Street LLC versus Capital Trust LLC and another. Mr. Masterson, when you're ready, you may proceed.
Thank you, Your Honor. Sean Masterson for East 4th Street. Your Honors, the basic issue in this appeal is whether the appellant's claim under the Usury Statute, Chapter 271, Section 49, is a valid claim and is not time barred. The original underlying loans date back to 2009 and 2010. The case was filed in 2019, and there were no payments made until from like 2010. I don't believe there was a payment made until the last payment was made in December of 2017, based on a demand that was made from one of the other mortgagees that were foreclosing on a property that was secured under these original mortgages. It is
Mr. Masterson, before you get too much further on that point, I just want to clarify one thing. The judge alluded to, although did not decide the case, on the basis of the April 15th, 2008 notice by Capital Trust to the Attorney General that intended to engage in a loan that exceeded 20%. Why doesn't that exempt Capital Trust and its successor from the criminal usury statute?
Well, Your Honor, I don't believe we ever got to that point in the trial court, because there's an issue of fact of when the notice was actually filed with the Attorney General's office. The loan was actually funded in April, although the loan documents indicate that it was executed in March of 2010. The actual loan or increase in the loan wasn't funded until April. So that's an issue of fact. I think the lower court made its decision based on, res judicata being one, in a statute of limitations two.
We can decide the case on.
Go ahead.
We can decide the case on any basis that appears in the record. That notice appears in the record, so that's the reason for the question. If we treat that initial disbursement and the subsequent modification as a single loan, it's not clear to me that the criminal usury statute should even apply.
Well, the issue, Your Honor, is whether that, in that case, the issue would be whether the increase in the loan, this modification, which we posit is a new loan, that was made after the original note that was on file with the Attorney General's office had expired by operation of time. Again, because the loan was actually funded in April. So while the court, there's two ways of looking at it. One is, hey, this was a single loan, and that single loan dates back to 2009. However, the increase in that modification established a new note. And that new note would have to be, in order for the protections of the statute to be afforded to the appellee, they would have to have had filed another notice with the Attorney General, and it hadn't been filed, again, because the loan had funded in April, not in March.
Well, so their response back is the loan had to have really funded in March because otherwise you would have been in default on the 2009 note, and also because actual money was not paid out to anybody. So what do you say to that?
Well, as to the default, it would be, I mean, the same parties were involved. In the lender didn't exercise its rights under the loan documents or I should say exercise its rights based on a default. It could have at that point decided, no, we're not going to extend the loan. We're not going to modify the loan. We're just merely going to foreclose on our security interest. It didn't do that. So I think the answer to that question, Your Honor, is that, you know, the lender waived that right to exercise its default in 2010 by modifying the loan.
You were about to get to your statute of limitations argument.
Yes, Your Honor. So in this case, there was a demand made in 2017 by the lender for the remaining amounts that were allegedly due under the note mortgage. It's that demand in subsequent payment by the mortgagee that was foreclosing at the time that restarted the statute of limitations. Now, there's a question that the appellee raises that it can't be a continuing violation. This isn't a rolling statute of limitations. And they cite to a bankruptcy court case that says to the extent that there is a continuing violation, the violation would be as to that last payment only. However, in 2017, the district court made a ruling that said, listen, it basically said, if in fact that payment or that event is an unlawful event, then it re-triggers the statute of limitations for the entire claim. It's the appellate's
Mr. Masterson.
Yes, Your Honor.
When I went back to your opposition to the motion for summary judgment in the trial court, I didn't see your argument that this argument that suggests that the time period reset in 2017. I didn't see that before the trial court judge. Did you make that?
We raised that in argument, Your Honor, that the payment in 2000, there was that demand in payment in 2017. And
is it anywhere in the record that we could look to that would show you raised that?
I believe in the transcript, Your Honor. If I may refer to I think I addressed that in my brief and notate the page on the transcript.
All right, if it's in the brief, I'll find it. I don't want you to waste time looking for it now.
Thank you, Your Honor. And the issue with that is, you know, under I cite a case in my brief, a United States Supreme Court case, Hormel versus Helvering, that basically says, you know, the rules relative to, you know, raising these claims, whether you raise it in the lower court and are able to raise it, if you don't raise it in the lower court, if you're able to raise it in the appellate court, the Hormel case basically says the rules are designed to promote the ends of justice, not to defeat them. So if, in fact, there's no surprise to the appellee that this claim is out there, meaning we raise it in oral argument in the trial court, then it can be briefed in the appeal and raised on the appeal. Because again, it's the importance, you know, there's a very important public policy position that's taken by the legislature against usurious loans. So I think that issue in and of itself, and also based on the reasoning of the Hormel case, should allow that issue to be discussed and to be raised on the appellate side.
And let me ask you about your res judicata argument. Why couldn't Mr. Dickey have raised in the land court the same argument with respect to usury that you now make?
Well, Mr. Dickey wasn't an obligor on the underlying note. It's the note that gives rise to the claim under usury, not the mortgage.
So
So
he was the principal of what is East Fourth, correct?
Correct. Correct.
So he certainly would have been on notice of the dispute regarding the enforceability of the loan.
Correct. Correct. But the issue is whether he, as a non-party to that note, would have the ability to raise that claim in any case. The claim would have to be raised by East 4th Street. And so if he doesn't have standing to raise the claim in the land court, then the land court wouldn't have subject matter jurisdiction over that claim. So any ruling by the land court as to res judicata effect on the usury claim would be moot because they didn't have subject matter jurisdiction to deal with that claim.
Has the Supreme Judicial Court now denied further appellate review on the land court actions?
It did, Your Honor. And again, those land court actions dealt with the assignments of mortgage. They did not raise the claims of usury. And again, from my position is that, Mr. Dickey, although Mr. Dickey had an interest in the properties, he wasn't a party to the note, therefore couldn't raise those claims.
Well, I mean, he signed the note, correct?
He signed it as the manager of the LLC. Yeah, he's not a, and it would be disingenuous of me to say that he's, unaware of it, or he is a stranger to the transaction. But it's a distinction where the loan is made to East 4th Street. It's a question of whether Mr. Dickey could raise those claims, or those claims belong to East 4th Street.
But that's a distinction you raise for the first time in your reply brief, correct?
Correct.
Did your client pay anything in response to the payoff notice at RA 68, the 2017 payoff statement?
My understanding, Your Honor, is that those monies came from a subsequent foreclosure, and the lender was paid from those foreclosure funds, because the underlying loan documents, the mortgages covered multiple properties. So that wasn't necessarily a check made directly from Mr. Dickey or East 4th Street, but rather it was from the proceeds of the foreclosure sale.
So my understanding is the money was paid to a receiver, and I guess what I'm trying to understand is where your client has some standing here. Like, if the receivership ended up with a positive balance, would it have been paid to your client?
Well, Your Honor, I may be mistaken, but I believe the receivership was the 2019 housing court case. That the demand came from my understanding is that the demand in December of 2017 came from a foreclosure sale.
And is that the payment you want to trigger the statute of limitations to reset it?
Yes. Yes, because, as a matter of policy, the loan in 2017, this payment re-triggers, it's our position that the payment re-triggers the statute of limitations for the entire loan, not just that last payment. And it does that because the payment of interest, if the interest were usurious, then any payment would be unlawful. And therefore, if you make an unlawful payment, it would reset the entire claim, not just that last payment.
But why, as a matter of policy, should it be able to revive payments that were made more than 6 years earlier?
Well, I think, Your Honor, it goes to a matter of equity, because not only do we have the appellate states that its note was satisfied in 2017. In 2019, the appellate relies on the same loan documents to basically make a claim in the housing court, that receivership case, to have the receiver hold out $70,000 or $75,000 to cover additional fees, legal fees that it had in dealing with these cases. So if the appellate can rely on loan documents, a mortgage, mind you, that was discharged by operation of law. As soon as the note is satisfied, that mortgage is discharged. Now, whether the mortgage remains on the land records, I think is irrelevant. As a matter of law, the mortgage only has power to the extent that there's an outstanding obligation on the underlying note. And by the appellee's own admission, the note was satisfied in 2017. That's number one. Number two, if we reverse the situation, in East 4th Street, after a 6-year, let's assume that a 6-year statute had expired, and East 4th Street decided to make a payment outside of the statute of limitations, then East 4th Street and their obligation on the note, the entire obligation, would then be revived. So as a matter of equity, what the appellee is saying is, listen, you know, okay, maybe there's one payment that is revived for purposes of usury, but not the whole thing. But yet if we reverse it, and East 4th Street had made one payment outside of the statute of limitations, then the entire loan would then be valid, right? The appellee could then legally sue, and not run afoul of the statute of limitations, and legally sue on the entire outstanding debt, not just that one.
I see your time is almost up, Mr. Masterson. Anything you'd like to add or further questions from my colleagues?
If I could just add, Your Honors, that I believe that this case is more an issue of policy than it is of contract. And the policy being that there's a strong position by the legislature to not have usurious loans, and that East 4th Street should be afforded the opportunity to litigate this in the state court. Thank you.
All right. Thank you, Mr. Masterson. Mr. DeMello, when you're ready, the floor is yours.
Thank you. Members of the panel, good morning. May it please the court. Scott DeMello on behalf of the Appellees Capital Trust and Endeavor Capital Funding, LLCs. Joining me at virtual counsel table today is my co-counsel, attorney Rosemary Trainey. The trial court properly dismissed East 4th Street's complaint for failure to state a claim. And while it based its decision on essentially two facts, statute of limitations and claim preclusion, which I'll address in a moment, the third issue that we had raised in our motion to dismiss was what Justice Kinder had asked Attorney Masterson about at the beginning of his argument. And that is, at all relevant times, Capital Trust had notified the Attorney General's office that it was going to do a high interest rate loan. And therefore, the loan in this case is immune from attack as being usurious.
So counsel, on that point though, he says there's a dispute of fact, and it seems a little muddy about whether the 2010 extension, whatever you want to call it, was funded in March or April. And he's saying if it was funded in April, you have a problem with the notice to the Attorney General. What do you say to that?
I would submit that it's not a question of fact, that that's actually a question of law that this court can decide, and it's in the de novo review capacity. There's no dispute over the events that transpired, and they're actually all contained within the record. First of all, there's no dispute that on April 15th of 2008, which is in Record Appendix 99, the Capital Trust had notified the Attorney General, and then under 271 Section 49, that notice is valid for 2 years. So that covers the time period of April 15th, 2008 to April 15th of 2010. There's also no dispute that the loan itself was on March 16th of 2009. So the initial loan where monies were actually dispersed, there's no question that at that time, the notification was valid and in effect. The only dispute, which I would submit is a legal dispute, is whether or not a modification that was signed on April 15th that did not change the interest rate, which I think is probably the most important thing. The only thing it changed was two terms. It added $50,000 to the principal, and it extended the loan for 1 year. There is no dispute that that was signed on April 15th of 2010. So again, it is on the last day of the 2-year period, but it is within the 2-year period. The other thing that's not in dispute is the fact that on April 15th, 2010, there was no money exchanged. There was no dispersal of monies, contrary to my brother's contention. This was a paper transaction. The parties had, as I had indicated, the parties simply increased the loan amount so that the borrower didn't have to make any payments, and then extended the loan for an additional year. So as a matter of law, not fact, the loan transaction didn't disperse on April 15th, 2010. There was no dispersal. The loan had one dispersal date, and that was March 16th of 2009. So just that by operation of law, the loan was not usurious because the statute provides if you notify the Attorney General, then you no longer can be attacked as a usurious loan. And so from our perspective, that is a way that this court can certainly affirm the dismissal on a different ground than the trial court, but it avoids this whole notion of having to decide which statute of limitations applies and which one doesn't apply. And I would just point to Levitz versus Chipman and Team Enterprises for the notion that that the loans are immune from attack, and also that it is at the time of disbursement. And there's no dispute there was no disbursement on April 15th of 2010. Turning to the statute of limitations issue, the trial court adopted the 6-year statute of limitations. This is a case where, unlike many cases, we don't have to worry about whether or not a plaintiff had knowledge or all the information that was necessary for the plaintiff to be able to file a claim. This plaintiff had filed an almost identical complaint in the Middlesex Superior Court almost 8 years earlier than this case. On August 16th of 2012, they filed a claim that the loan was usurious. So at that point in time, from our perspective, their claim has accrued, and it's accrued because they know that they have suffered an injury, and they know who they claim to be the person that caused that injury. And we don't have to speculate about that. We can just look at the complaint that they filed. While the usury statute doesn't provide for a limitations period, there really are just 4 different possible limitations that would be possibly applicable. One is the contract limitations for 6 years, a negotiable instrument limitation, which is also 6 years, a tort for 3 years, or it could be the consumer protection statute, which would be 4 years. I would just posit, as we do in our brief, that the 6-year limitation is at least consistent with the criminal 6-year statute of limitations. And considering the fact that this is a criminal statute, there is some, there's some symmetry to the fact that you would pick the contract or the negotiable instruments. However, what I would point out is that the federal courts that have applied a statute of limitations issue or dealt with the statute of limitations issue, they have pretty much universally applied Chapter 260, Section 5A's 4-year statute of limitations under the consumer protection as a.
But as I understand your argument, Mr. DeMello, you're suggesting that we apply the greatest statute of limitations, the 6 years, and in any event, you're saying it was long overdue, even if we apply the longest statute of limitations.
That is correct, Your Honor. And that's the reason that we push the 6-year statute of limitations and the motion to dismiss, because it gives the benefit of the doubt to the borrower on any applicable statute of limitations, and under any of them, which the longest one being 6 years. If you take that, you go back in time from the time they filed their complaint, all operative acts had taken place already at that point in time. I would point to the 2 primary federal cases. One is In re Lucheski, which is a 2013 bankruptcy case that applied, which I'll talk about in a moment, a rolling statute of limitations. But the other case, which was Filoni versus Coco, didn't apply a rolling statute of limitations, and that's a 2019 district court case. And I think Filoni is much more consistent with what our position is in this case, and also factually consistent to the extent that there was a series of transactions, different loans going back and forth. The borrower made several payments on that loan. And then several years later, there was actually a complaint to enforce the loan by the lender. And the district court applied the 4-year statute of limitations from the date of the note. And they found that at the time that the borrower signed the note, they had all information that was necessary to bring a usury claim.
Can we talk about Mr. Masterson's argument that the statute of limitations somehow reset in 2017? And before you get to the merits of that argument, can you tell me whether or not, in your view, it was preserved?
So I would first, on the preservation issue, the resetting argument was not preserved. What I will agree with is that the appellant had mentioned down below that there was a continued, quote, enforcement. But there was never an argument about resetting the statute of limitations. There certainly was no citation to any case law. If you look at the memorandum that my brother filed in the opposition to the motion to dismiss, there was no citation other than just a general statement that that they had continued to enforce the promissory note. There was no references to anything in the record regarding that. Didn't even reference this alleged demand letter, which I would point out to the court is not a demand letter. It was a payoff statement. And they didn't even reference that letter in their argument or in their memorandum. So from our perspective, that falls in the category where there's some sort of brief references to stuff, but not of a substantive enough nature to preserve it for appellate review on the resetting nature. On the merits, they kind of rely on two different doctrines. One is the continuing violation doctrine. We would submit that the continuing violation doctrine doesn't apply. For that to apply, there needs to be a series of events where each individual event isn't enough to rise to a claim, but collectively does. Sexual harassment in the workplace is the classic example of that. In this case, East 4th Street basically says that this loan was usurious from the very beginning. The moment pen was put to paper, the loan was usurious. There's one event, no other events. The two events that they do point to really are not the type that, quote, reset the statute of limitations. One is the 2017 payment from the third-party lender. First, it's not a payment of an installment payment by the borrower. It is a payment from a third party as a result of a foreclosure. It's not the result of a collection action by Endeavor. There's no evidence in the record that this was a collection effort by Endeavor. What I would posit is that there is a mortgage on record and that a payoff statement was requested and that payoff was then made by the third party. And there is no demand letter. It's a result of the mortgage.
Does this somehow affect either Mr. Dickey or East 4th Street? Does it change whether money is available to be paid to him or to East 4th?
So yes, I think that the payment would, if there's a payment made from the excess proceeds, then there are less payments that are made to Mr. Dickey on the balance of the foreclosure. So from that perspective, they would be affected by it, but it's not a payment by them where if you look at the cases that apply a rolling statute of limitations, they apply it when there's been payments made by the borrower because the borrower is then taking some affirmative steps, and this is not that case. And the same thing with the 2019 request for attorney's fees. That was a $75,000 set aside, which, by the way, didn't even get paid yet to Endeavor. That's being held by the receiver or the court post sale of another piece of property, which again, that was not a payment made by the borrower. So we would say that the continuing violation doctrine doesn't help because it just doesn't apply. Then you get to the rolling statute of limitations, and that's basically what Judge Hoffman applied in the In re Lukeski case, where essentially you look at the time the complaint was filed, look at the window of the applicable statute of limitations, whether it's 6 years or 4 years. And again, in this case, it doesn't really matter because if you go back 6 years, the only payment that could possibly be made was the 2017 payment that paid the loan off. And when that payment was made, we would again say was made by a third party and should not go about giving the rise to of resetting. It certainly doesn't reset the statute of limitations. On a rolling statute of limitations, that payment in and of itself creates a new limitation window. So you would measure 6 years from the date of that payment forward, and therefore it falls within the claim and they can challenge that payment, which is how Judge Hoffman dealt with that in the Lukeski case. We don't believe it applies, but even if you did feel that the rolling limitations period was the applicable rule to apply in this case, they would only be, the rest of their claim would be dismissed because they can't challenge the entire loan, even under a rolling statute of limitations. Just briefly on the claim preclusion.
Argues that res judicata is inapplicable for the land court actions because the land court lacked subject matter jurisdiction over usury claims. What do you say to that?
Yes, they don't lack subject matter jurisdiction, and I think my brother doesn't even claim this because there's no citation that land court doesn't have subject matter jurisdiction over the usury claims. I think what their claim is that they don't have subject matter jurisdiction because Mr. Dickey allegedly didn't have standing. So if he doesn't have standing, they wouldn't have subject matter jurisdiction or subject matter jurisdiction. We disagree with that. If you look at it, as my brother indicated, and I was going to use this phrase, but he used it first, which is that he was not a stranger to the transaction. He's clearly the manager of East 4th Street. But I think even more importantly, that does give him a direct standing link. He's a guarantor of this loan, and that's found in the record at Record Appendix 23. Which is at the end of the note. The note references the fact that Mr. Dickey is a guarantor of the loans as part of the security for this. And that gives him a direct connection to the loan and whether or not it is enforceable. So it's the type of thing where he suffers a personal injury, particularly where his claim is that the loan is void. And because he's making the claim that the loan is void, obviously that affects his guarantee. But I think more importantly, it affects the underlying foreclosure. Because if we have a situation where this court allows this claim to proceed and, say East 4th Street prevails, you could then end up having a situation where the Superior Court in this action finds the loan void, but the foreclosure has already been found to be valid. So you'd have a foreclosure of a loan, which you can't have a foreclosure when there's no valid underlying debt. So by just challenging the foreclosure, that was the strategic decision that was made by Mr. Dickey. He chose to do it that way so that he could proceed pro se. He should not get the benefit of that strategic decision to basically claim split, which is what he's doing. This is the classic definition of claim splitting. Unless the panel has any other questions, we would rest on our brief and we would ask that the court affirm the trial court's dismissal of the complaint with prejudice for failure to state a claim.
Just so it's just on one issue you just raised on his being a guarantor, he didn't sign anywhere as a guarantor though. I mean, right below where it says guarantor, it has his signature as manager.
So, well, I would just say in the record that is correct. However, outside of the record, which is obviously not before this court because we didn't need to, there was no need for us to submit it as part of the record. There would be a separate written guarantee, which is what that is referencing in the note. So there is a separate written guarantee that Mr. Dickey would have signed as part of the loan documents.
All right. Thank you very much for your arguments. They've been